things from all of you.
Yes, sir. Life is a learning process, sir. Absolutely.
Absolutely.
Yes, sir. Ma'am, can we begin?
Yes, ma'am. Just 1 minute.
Yes.
Yes, yes.
Good afternoon, everyone. Honorable Advocate Biswajit Das, sir, our chief guest for the said event. Honorable Advocate Rajendra Umap, sir, Vice Chairman of Bar Council of Maharashtra and Goa. Our respected Dean and in charge Principal, Dr. Ujjwala Bendale, Madam. Learned faculty members, friends from the student community, and all those joining us through the digital space. We, on behalf of the Bharati Vidyapeeth, deemed to be University, New Law College Pune's Student Progression Cell, welcome you to yet another enthralling session on an interesting new topic of jurisprudential innovation in law and scientific dimension in legal profession. Before we proceed, may I request our dynamic and visionary Dean and in charge Principal, Dr. Ujjwala Bendale, Madam, to kindly grace this occasion with few words.
Thank you so much, Yash. Good evening, everyone. Welcome to this webinar on jurisprudential innovation in law and scientific dimension in legal profession, organized by the Students Progression Cell of Bharati Vidyapeeth New Law College in collaboration with Bar Council of Maharashtra and Goa. Today, I take this honor and pleasure to welcome a very versatile personality of law fraternity, and he is Mr. Biswajit Das, sir, Advocate, Supreme Court of India, Managing Partner, Juris and Juris. Welcome, sir. Sir, today I am here to introduce you formally to Bharati Vidyapeeth deemed to be university. In very short time, I'll introduce you to Bharati Vidyapeeth and the New Law College. The institutions of Bharati Vidyapeeth were accorded deemed university status in the year 1996 for its academic excellence. Bharati Vidyapeeth is accredited with A+ grade in 2017 by NAC. It has category 1 university status by UGC, and it is ranked 68th by NIRF. So this academic excellence of Bharati Vidyapeeth has been possible only because of the vision of Honorable Dr. Patangrao Kadam Sahib, founder Bharati Vidyapeeth deemed to be university, who at the age of 18 years decided to establish Bharati Vidyapeeth as a distinct educational institution. So today, Dr. Patangrao Kadam Sahib is the guiding star for whole of Bharati Vidyapeeth fraternity. Presently, under the excellent guidance of our beloved patrons, Honorable Professor Dr. Shivaji Rao Kadam Sir, Chancellor Bharati Vidyapeeth deemed to be university, Honorable Dr. Vishwajit Kadam Sir, Pro Vice Chancellor Bharati Vidyapeeth deemed to be university, Dr. Asmita Tai Jagtap, Director Bharati Medical Foundation, and Professor Dr. Manikrao Salunke Sir, the Vice Chancellor Bharati Vidyapeeth deemed to be university. Our new law college, Bharati Vidyapeeth, is consistently ranked among the top law institutes of India by Career 360, Outlook, The Week, India Today, Education Post, and so on. So the New Law College has always been accredited and re-accredited, and I can tell you that A+ grade by NAC was accredited in the year 2007, and we have also received the Gold Star Award from Bar Council of India. Last year, New Law College has been awarded with Best Law College in India for Research and Pedagogy by IIRF Education Impact Awards, New Delhi. Then we are the awardees of the prestigious Best Legal Aid Center Award 2019 by Knowledge Teas, New Delhi. Further, so when we talk about New Law College, we aim at training and producing legal professionals well equipped with advocacy skills, meeting up with the current industry standards. The students of our organization, they play a very integral part in organizing all the events as well as working integrally for the institute, and wherein they have student initiative based cells such as the environmental cell, the advanced exploration training for intellectual property and cyber law cell, moot court society, Legal Aid Center, Legal Research Center, Society for Advanced Research and Analysis of Labor Laws, then Center for Community Development through Law, and the Student Progression Cell. When it comes to the Student Progression Cell, so this cell is an initiative to train the students for becoming more practical oriented and prepare them to become the future judges, advocates, solicitors, corporate personalities. The core aim of this particular cell is to focus on educating and preparing the students for practice in the courts and judgment writing, drafting, and presentation preparations. The main core aim of the cell is to boost the confidence of the students towards becoming professionals. Further, this cell will, of course, and is progressing with, training the students in different particular, you can say, professions, or rather we can say faculties, but majorly we do it through different seminars on professional ethics, mooting skills, development skills, scope in legal fields, opportunities whichever are further available under law. Besides that, every month we conduct certain trainings for them through Bar Council of Maharashtra and Goa, like the judiciary exam, NetSet exams, judgment writing, preparing for appeals, revision appeals, and so on. So these are all the particular activities we conduct under this particular student progression cell for the students. And herein, I believe, so with the guidance of all you, you can say stalwarts from the law fraternity, the students are going to be blessed and they are going to grow more in leaps and bounds in this particular profession. And I wish you to bless us with your particular words of wisdom today. And I really express my heartfelt gratitude towards you for accepting this particular invitation and enlightening us through this particular webinar. Thank you so much. And over to you, Yash.
Thank you very much, ma'am, for those enlightening words. Now, the scope of law as a discipline seems to be expanding with every passing day, particularly with advancements in the field of science and technology. Law being the king of kings, as is rightly said, it regulates all these spheres in their individual capacity. Therefore, understanding their interaction with the law becomes important. Hence, this makes a clear ground for jurisprudential innovations to understand these interactions more deeply. And for this, we are joined today by none other than Honorable Advocate Biswajit Das, sir, a powerful speaker, a masterful orator, and a true polymath. Sir is a practicing advocate at the Supreme Court of India and managing partner of Juris and Juris. Their good selves specialize in wide variety of areas from corporate law, mining laws, environment and forest laws, etc., on account of their deep knowledge of constitutional principles and rule of law. A strong believer of law being a simple arithmetic and its outcome being predictable and uniform, their good selves hold a degree in BSc Chemistry, a law degree in the field of commercial and financial management. Their good selves have a distinction in holding a CA degree, a CS degree, and a CFA degree. Along with this, Sir is also a part of the advisory committee on GST, Center for Health and Environment and Food Safety. And their good selves has also been giving crucial inputs on public policies to governments at both state and central level. We are truly blessed to have you serve with us this evening. May we kindly request you to kindly address this gathering. Thank you.
Thank you, Yash. It's indeed a privilege for me to be here before your august audience, and particularly the college, the New Law College. I must convey my gratitude for inviting me for this occasion, and Bharati Vidyafeet and the Students Progression Cell, and in particular the organizing committee members, and Dr. Vijala Bendale, the Dean and the in-charge principal of the college, as well as the Sri Rajendra Ugma, the Vice Chairman of the Council, Bar Council of Maharashtra and Goa, and the members of the organizing committee. Thank you once again for inviting me for this occasion. Well, I always, because teaching is a subject which I always connect, because before I began as a professional practitioner, I was a faculty there in the IBS Hyderabad, but left the job after a very brief stint out there. But then ever since I've started practice, it has always given me a kind of a dimension which excites me more in the profession is something new. I'm not somebody who will follow blindly something is given to me. And from a background of science with an analytical bent of mind, you always see things a little differently. Initially, and over a period of time, 20 years, I've already completed in the profession, and always understood and always practiced that law is certainly mathematics. If law is not predictable, then this is not law. I would like to call it as a lawlessness. And this has been always my standard of practice, a barometer of which I have fixed it for myself. And before I form any judgment, because we are not the lawyers, we are actually the lawyers, we are not the judge. After all, a practicing lawyer always has a responsibility, not only towards his or her client, but also he has an utmost responsibility towards the court and in turn to the society. So therefore, the new generation of lawyers, like the new law college, the college which is organizing this event, the new law college, for that matter, the Bharati Vidyapita deemed university. I'm sure a lot of students are getting very well trained these days, and the new law college has the best of the faculty. But what is intriguing, and I ask these questions to all of my colleagues out there who are part of today's listener to debate. Today, I'll be the listener to them tomorrow. I wish one day I'll be listening to your galaxy of students coming out of this position of studentship and becoming a good of lawyers, to good of judges and other dignitaries in the society. But at the end of the day, what for all these exercise? Today I'm a speaker, tomorrow someone else will be speaker. But point is, in the legal profession that we belong to, either as a practitioner today or the students that today is there in the audience, what should be their approach towards this profession? And the topic that I have chosen, when Yash asked me to take up some kind of a subject, I said that there are a good number of faculties out there in your college who can be a very good speaker than me on academic side of subjects, whether it is labor law, whether it's a mining law, whether it's the environment law, tax laws. But let us talk a little differently. And I always wanted to be interactive with the students, though the COVID-19 era has given us a different dimensions to interact with the people even with 1,000 miles away from each other. And the virtual mode of interaction, though is not being percolated in all of us, because still we feel that we should be physically there to convey that energy, that conviction, and that conviction, which is something which is enthralling in the physical presence. Whether we are able to communicate that, certainly over a period of time, we'll learn this art of even communicating in a virtual mode. This jurisprudential innovation in law, what is this? And then the scientific dimension to the profession. If you see this, it has a direct connect and connection to the core of law. What is law? I'm a lawyer. A client is coming to me. He's saying, sir, this is my facts. Now, I see those facts. He will go to another lawyer. He will also see the same facts. Then these facts will be given to the honorable judge. He will also see the same facts. If the facts for a particular case does not change with respect to that person, then can there be a outcome different from each other depending upon the persons? If I ask this question to all of you, which actually bothered me over a period of my stint as a practitioner, that if a person comes with me with a set of facts, what should be my opinion to him or her? If the set of governing law to those set of facts for that particular person is finite, and the facts to that particular person is finite, is this not in a sense, as a combination of set of facts and combination of set of law, for that particular person, is it not finite? Now, if it is finite, what should be the outcome? In science, in logic, we were taught the input is equal to output. Now, if the input is finite, the output will be finite. Now, if it is so, then how come a set of provision of law will mean differently to different persons, or for that matter, different from different courts? Because we call it as an interpretation of law. I hope. Am I audible now? Am I audible? Because I am not able to see the screen.
Yes, sir. Yes, sir. Clearly.
So I am completely blank. Actually, I am speaking to a blank screen. So anyway, now, so what I'm saying, that new generation of lawyers and the students who are going to their profession, I always have a piece of advice to them. Try to be a little different. And that is where the cream lies. Then what should be that different? Provided you see that different in the direction of equilibrium, in the direction of idealistic, in the direction of the universal correct position. And that difference can be seen from different prism, depending upon different person's perception. And if I would like to be more interactive with the students to be able to answer the pointed nuance, my submissions, my points, for them to understand in the dimension where we are talking about, that today, a provision of law, for example, say this section 375 of Indian Penal Code, only very recently, that is yesterday, a division bench of the Delhi High Court gave a split verdict. I asked these questions to all of my students here, or the dignitaries out there, to analyze a particular text of law 375, definition of rape under Indian Penal Code, is seen by two judges, honorable judges of the Delhi High Court, who gave a verdict yesterday, giving two diagonally opposite opinion. There were two sets of lawyers. One set of lawyer challenging through a PIL into the various of section 375. Another set of lawyer, they defended this 375. Now imagine the same text is seen by all of us. But one other honorable judges sided with one set of lawyers' opinion, and the another honorable judge sided with the opinion of the another judge, another set of lawyers, erudite lawyers. Now, in the process, what is the casualty? I ask these questions to myself as a professional. Can a provision of law mean differently to different person? If the very idea of law is the civilization, if the idea of law is the civility, which is intended to achieve the uniformity, how can a provision be understood or meant differently to different persons? And if it is so, how can we secure a uniformity in the society on the basis of a text of a law whose idea at the time of legislation is always securing a uniform and orderly society? If you ask this kind of inquisitive questions to yourself, you will always be able to innovate something interesting out of it. And I have another piece of advice, that how come the world that we live in today, that we, the people of India, through the Constitution, authorize the institutions like Parliament, state assemblies to make a law for us, to make an orderly society, and they make a law, and then subsequently through we the lawyers, reflecting before the court at the time of interpretation, saying the intention of the legislature. How does it matter? Tell me. Can the intentions of legislature as a concept of interpretation of law before the court, I may say this is the intention of the legislature, even though I see the same text. The B set of people will see it the same way, but they will interpret it differently. If such a possibility is there, that a similar identical text read by two different set of people, reading it differently, understanding it differently, are we achieving a civility in the society, securing an orderly outcome? And if we are not able to get that orderly outcome, then can we claim that we are truly living a truly civilized state of affairs? And with the innovation of new dimension of law, for example, the Indian Insolvency Bankruptcy Code, for example, your money laundering law, with a new designed jurisprudential concept, legislative concept, inversion of the presumption of innocence, etc. Are we, the lawyers, are discharging our duty to the society and to the honorable judges by reading the older jurisprudence to deal with the new dimension and new design law? I ask these questions to myself. Am I doing justice to myself? Am I doing justice to the society and to the honorable court if I will go to the court and interpret the money laundering law, which is giving a completely new design, jurisprudential idea, legislative policy, by reading the judgments of the old 50, 60 years, though jurisprudence which is developed 50 years, 70 years, 100 years, have they encountered these designed law at the time of interpretation? And are they proportionate to be able to see the reflecting and reflection in today's understanding of the new design law? Whether it is Insolvency Bankruptcy Code, whether it is the Disaster Management Act 2005, whether it is the Food and Safety Authority Act, FSSI Act, FSA Act, that is 2006, whether it is your money laundering law. So therefore, mere studies in the academic sense, the way you read it, the way we are getting taught, may not be the universe for ourselves. It is as much an essential for us to look for something new, provided we will be able to get a tranquility in the outcome. I always say, if the law is not uniform, if the law is not predictable, then this is not law, this is lawlessness. But then, who will get it? There are institutions, there are parties, there are lawyers. It's responsibility for all of us. But then if you have to take the baton in your hand, discharge the responsibility to the fullest extent, and for which a new dimension of understanding of law is extremely essential. As I told you, 1 + 1 is 2. It cannot be anything other than 2. And that is precisely the law meant to be. But then we say that's the interpretation of law. Now, a person can have a different interpretation by reading it differently. It depends upon us that how we can interpret in a manner that it remains unambiguous and cannot have a violent effect. That is where the jurisprudential innovation as a concept is extremely important. Say, for example, as I told you, in the Section 375. I am basically a commercial lawyer, having, as Yash told you, I have a commercial background. in the professional, commercial, educational background. I started in the commercial practice, merger acquisitions, taxations, commercial, corporate law, foreign exchange, etc., banking, finance. But then I entered into the constitution over a period of time. And with the engagement and involvement of the scientific tools, I literally mean to say, I use the scientific tool in the application of law. And it has been always my endeavor to bring about a errorless proposition to the court, which cannot have more than plausibility. If we will be able to achieve that level, then only we will get a predictable result. Otherwise, I would be expecting a predictable result by reading a particular way. It may so happen that the honorable judge may have a different reading, provided I leave that space to read it differently. And that is where, before you guys go to the court, you invest 1,000 hours to get to that level of clarity, to make sure that your outcome remains predictable. And that's your responsibility, that your client or the person concerned who is aggrieved of get a predictable outcome. And the responsibility lies in you, by which, and let me tell you, if you apply the older jurisprudence, today, those those people who are practicing in the courts like me, they all know the older jurisprudence are no more holding the remit of the courts today. And with the new dimension, new design law staring at us, it's like this: going to the Tibetan border and fighting with the Chinese new weaponry, with the 1947 Indian weaponry. It's no match. Now, if you agree with this, then you also have to endeavor that you have to innovate the jurisprudence. And one of this, and let me explain you to the extent of the section 375 for a moment. 375 is a subject of rape. And world over, marital rape in a society now evolving, women are getting empowered, we are all now equal, and therefore there is a clamor that the women also must get a parity even in our criminal law justice system. And then that is why, where the British law and other laws, they have changed, giving that parity, and marital rape is recognized in some of the countries. Indian, the generations, the present generations are looking for it, and they are also trying to do it. That yes, the marital rape also should be recognized as a rape and should be punished like any other rape. Now, this is a subject, let me be very honest to you, is something I fully agree that there should be absolute parity. But I do not wish to hold one view or the other when I approach the court in the 375 challenge, because for me the issue was far larger than the gender inequality. The far larger because it involves and it affects the very idea of law. As I told you, the core of the law is always predictable, because it is always, law means what? We want a legislation as a law to govern us. It must govern us uniformly. It must govern us predictably. And that is where, that's the ideal state, but something which we are not living in the world of ideality, and therefore we may not expect that to happen immediately. But at the end of the day, at least we should endeavor to achieve to that level of ideal state. Now, when it comes to my intervention in the rape law challenge in the court, I was more concerned with the predictability of the law, core of the law. Why? For me, it was not an issue of the marital rape. For me, it was also not an issue because both parties were fighting. One party, one batch of people who challenged this matter, they argued that marital rape should be legalized. And then the other party, other state, whether it is state or other bunch of people, they said, if you will read the law in that way, then you will be creating an offense. So therefore, the second set of people were saying, by virtue of recognizing marital rape in Indian jurisprudence, we will be leading to a situation of creation of offense. So that means virtually before the court, there were two sets of actions. One, marital rape as an issue. Second, there is issue of creation of offense by the court. How? I'll explain that. But to say that why I intervened with a scientific presentation. And my intervention was beyond the marital rape, beyond also the creation of offense. My purpose of intervention was to see and to guide the court that it should not venture into a dimension which will unseat and destabilize the very idea of jurisprudence. How? I will explain you a little later. The definition of rape, as we see it in section 375 of the IPC, the legislature has designed the language, couched the language in a particular fashion. It's a definition section. Now, in the definition section, the set of people challenging the wideness of section 375 claimed that the exception 2 to the section 375 definition of rape creates a protection to the husband who forces upon the wife and commits non-sensual, non-consent sex. And therefore, they should be regarded as rape. So in other words, they were expecting the court to declare the exception as an ultra vires, the Constitution, on the anvil of Article 14, 19, and 21. I am not going to explain you about the nature of the challenges. I'm only giving you a dimension, a scientific dimension, a scientific dimension of the legal profession, that how we, the professionals or the new generation of students, have a responsibility, that how they can navigate the court to come to a conclusion where the court, both of the parties were arguing with a utmost sincerity and giving both the dimension of argument with a fair degree of credibility. But we have to also understand that this is not a legislation exercise. This is actually a virus challenge before a law court. So there are perimeters of the court. The court operates through some rules and regulations that the court cannot create a law. It at best will declare the law, that we all know. A. B, if you delete a particular portion on the ground that it violates the Constitution, what will be the ultimate effect? The ultimate effect will be a class of people or a class of action, that is husband between wife, non-consensual sex, will become a rape definition, which earlier was retained outside. Now, therefore, two sides of the people were arguing vehemently on one with the other. It appearing to be, if you will argue the first side of the argument, you will see that, oh, it appears to be very, very logical. If you read the other side of the party's argument, you will say, oh, it is also very, very logical. But let me tell you, in this, seesaw fight, how we will be able to bring about the logic into it. So a Venn diagram was drawn and a Venn diagram was to be presented. Now, if you will be able to show it in a scientific manner, it will give you a clear-cut idea that where you are actually guiding the court. What is the time now? Where you are actually guiding the court, that if you go beyond this, that means you are actually entering into the territory of legislation. And if you do not go into this, then you will be. So in other words, the dimension has to be shown in a graphical presentation to be able to bring about a change and to be able to bring about a clarity to the court that is it really encroaching into the domain of the legislature, or is it actually deciding within the perimeter of the lawful courts. Interestingly, if we'll read this judgment, which is given a split verdict, the one honorable judge says, there has to be a need. Mark my word. There is a need that a forced sex upon the wife should be regarded as a rape. While observing it, the court declared it as ultra vires on the ground of the Article 14 on the classification side. And then the Article 21 saying it violates the right to life of the wife. The other honorable judge argued, no, the exception creates a classification, which is, there is an intelligible differencia, because the husband as a classified, a class of persons are a different class altogether. And there is an intelligible differencia between the husband and non-husband class of men forcing upon a woman. And then there is a nexus between the objects. So we all know that jurisprudence. So I need not have to elaborate that in a challenge of a virus, how the intelligible differencia, Article 14, and then the object seeks to be achieved. These are two twin tests to be applied. So what is my purpose of giving you the marital rape judgment as an example to explain to you all that a scientific dimension is necessary. Now, if you see these two views of the two honorable judge, one says there is a need, and therefore he went on to declare it as ultra vires. The other judge argued on the exception, and then to the extent saying that this exception, there is a intelligible differencia, and then that jurisprudential constitutional concepts being applied to say that no, it is not, it doesn't violate the constitution. So therefore, two different views. I, as a lawyer, ask myself this question. If I was before the court and I was assisting the court, could this be a possibility that the two honorable judges can read it differently? Or any of us already there and the honorable two judges are forming two different opinions? Can this be said that is it a free flow and reflection of the true law by reading the same text by two different class of people? Same way, and sedition law, which is a 150 years old law. Now the Honorable Supreme Court has stayed it. Now earlier there were Supreme Court judgments which upheld that law also. That is why we were sharing that judgment. So what is the change? Is this that there is a change of honorable judges and therefore there is a change of interpretation? And believe me, my friends, if you will delve upon it in a critical thinking, you will see there is a vast territory of jurisprudence which is not even seen by us. And they're so interesting. We are still reading the Lord Denning, Lord Atkins, 150-200 साल पुराने jurisprudence हम अभी भी पढ़ रहे हैं. और हमारे सामने मनी लॉन्ड्रिंग लॉ ऐसा है कि वो बोलता है कि you are proven guilty till you disprove that you are. I mean, the onus is on you. It is no more a jurisprudence that may there be 100 guilt go scot-free, but one innocent should not be penalized. That jurisprudence no more operates today. So therefore, we have moved on to a different era, different territory. Now, this is where the responsibility lies with all of us to explore the possibility. We have never tested what is the meaning of we, the people of India. We have never tested what is the true meaning of the public interest. Now tell me, if the public interest as a concept is universal, is there any relative weightage available that if central government is arguing differently and the state government is arguing differently, therefore the central government will have a better public interest vis-a-vis the state government public interest? Have you ever analyzed this concept? Have you ever analyzed the article 32 to 26? Have you ever analyzed the article 21, 19 in a different dimension? The dimension that is being taught to us, not that. I'm not talking about that. I'm saying, can we innovate something interesting which will make this life much easier, and this society will live in a very, very predictable environment, so that just because the honorable judges or the honorable court changes, the view will change. We do not enter into that era. Now, I wish I could have interacted with you all. For example, the new law, drug and cosmetic law, which is now being redesigned by the central government, is planning to change this 80 years old law, 1940 law, Drug and Cosmetic Act. Government of India is now looking to change and bring about a new law. Now the new drafting committee is actually sitting and trying to give a new design law. We have also chipped in with our idea that, in a prosecution, we all know that concept of your compounding. But believe me, ask any lawyers, hardly any of us apply it in true sense, the compounding provision. In almost all special laws, compounding laws are there. Even in the Indian Penal Code, CRPC also provides the compounding provision, but we hardly apply it. And there also human intervention happens. We have designed a model, a tool, whereby we have given a mathematic formula by giving a weighted average formula, covering all the factors, all the possible factors. It is designed in such a way that even up to 10 years, 20 years hence, this law, this model will continue to give you a predictable result, because it has factored all the future possible factors into its consideration in its formula. And the court will also not intervene. Parties also will not have to intervene. A form will be filled in by them, and the computer will generate what the penalty, what the composition, compounding fees will be. In that, at the day one, without even getting prosecution begun, a party can simply pay that money and get away. Because there are many offenses which is running into 15, 20 years, which is inconsequential, which could have been decided at the threshold. But then the amount of the government resources getting wasted, the court's resources is getting wasted. After all, 1.4 billion population. Today, only 4-5% populations are going to the court. Imagine, with the economy growing up, how many people will go into the court? Today's infrastructure, court's infrastructure is not ready to deal with it. That's the reason why the existing quantum of litigations are not being able to effectively adjudicated by the court, and the delays are 10 years, 20 years, 30 years. Imagine the number of population growing up economically and asserting for their rights. What will happen? So therefore, automation is the key. And my friends, tomorrow you will become the lawyers, you will go to the corporate, you will also become a judge, you will also go to the government. I always have a piece of advice: try something different. The difference, only you have to identify what that difference are we talking about, which will have a huge macro benefit. If we will be identifying only one, it's a good enough for an entire life to live with that innovation and still make it effective and successful for you. Imagine the Elon Musk with a one innovation, two innovations. Look at this way they are. So why can't? And I always am now predicting that the lawyers, now today's generation of lawyers and the next generation of lawyers, there is a huge space for innovation. Whether it is jurisprudential, whether it is tools, scientific tools, techniques, whether it is the applications of the artificial intelligence in the judicial governance, each one of these holds key for our future, and that it depends on us to identify what are those. You read the books, all right. You read the books. Your teachers are telling you, they're guiding you, all right. But try to be a little different than what you are being taught to make your future better, to make this, because this profession is heavily competitive, stereotyped, and those, old methodologies are not yielding much. It is creating a lot of confusions. And that is important, that whether you are ready for it. And I'm sure the new law college, probably with the time changing, will bring about some kind of a new curriculum change, where a scientific approach, because this is only a 45 minutes of I could have given you a presentation, a dimension, even in fact, the dimension which I was talking about, the rape issue, marital rape issue, how it's so beautiful, how you can pinpointedly say, look here, the honorable judges, you are actually transgressing to the legislative function. If you do this, if you write this, it has a transgression. If you do this, it has a, consequences somewhere else. Can we show that? Something I'm looking forward to help you guys to really understand this dimension. I would like this thing to be more of an interactive. I, in fact, suggested to the organizing committee that they can pose any kind of a questions if they have. I'm sure 45 minutes certainly is not good enough, but I have just given a small glimpse of where this new area for practice can become more lucrative, not only for yourself, for your clients also, because see, that is the reason I will always get my results. I always get my results because I take it upon myself. If the honorable judges are not able to understand, it's my fault. I have not been able to persuade them. It's somewhere I lacked it. All right. So hope that I think some kind of a questions can pose to me. I can answer them to be able to make it more interesting.
Thank you, sir. Thank you very much for this exposition. I must confess, every word spoken by your good selves, it gave us a new perspective of jurisprudential innovation. Sir, I'm also equally happy to inform you that the new law college in its curriculum consistently tries and has incorporated the newer changes that take place in and around the field of law. Sir, we have received some questions. If your good selves would permit, then we shall proceed with the Q&A session, sir.
All right, please.
Yes. Thank you, sir. Thank you very much. So the first question is posed by Mr. Aniket. He asks, to what extent can PILs be adjudged as a jurisprudential innovation?
Well, PIL actually, Honorable Justice Bhagwati, the Honorable Supreme Court Judge, developed this law for a person who was not before the court, and he developed that law over a period of time. This PIL has grown to the extent that you heard yesterday 2 judgments, one from sedition law, where at an interim stage, a law which was in operation for about 150 years, were at the interim stage stayed, virtually stayed. And second, the marital rape, as I discussed about, that there are 2 split verdict is there before. I mean, it's a division bench, 2-judge bench judgment. So therefore, for the time being, 375 remain, but with a 2 different, diagonally opposite opinion. Now, PIL as a jurisprudence, let me tell you my personal view, and that is also part of a scientific dimension. What is PIL? You will not see as a text, as a legislative text anywhere. It is only 1984 Supreme Court judgment brought about a concept of PIL under Article 32. Directly. A 32 petition was filed, they entertained it, and they granted an order saying that the voiceless, faceless people who are not before us and who could not come to us, so we are passing that order. But that order in 1983-84 was against state and in favor of a party. But today, the PILs are filed under Article 32 to 26. Ordinarily, these are basically read jurisdictions only because they entertain under 226 and 32 only. So for a PIL, there is no different provision. These are the only two provisions available in the Constitution. 226 is before High Court, 32 is a Supreme Court. Now, when you file this petition, generally we, the individuals, are filing it because we also know that Article 32 and 226 can be entertained only by those people who are eligible for that kind of fundamental rights, who are alleging a breach of fundamental rights. But here, the jurisprudence is developed to this extent that the person who is not having a interest in that cause, who will have to give a declaration that I have no personal interest, he will file a Article 32 and 226 petition, and the Honorable Court will entertain it in the name of the public interest. But the orders which are being passed will have a consequences which can visit to some individuals. Because the very premise of the PIL is that because the state is not acting, even though it is duty bound to act, therefore the court will intervene. But that is actually a public justice. PIL is what? The public justice. But fundamentally, the Constitution permits public justice to be delivered by the political class. And the political institutions like Parliament, Executive, the third limb, that is the court. The aggrieved will go to the court for protection of their rights and liabilities. If the aggrieved goes to the court, it has to be the last man standing in the mile. That's why we call it as in a democracy. A last man standing in the mile have a remedy in the institutions of a court. Now, if somebody will go to the court and get a judicial order with respect to an executive, dereliction, then what ultimately comes out is an executive function in the form of a judicial order. Now, imagine Article 32 is filed and an order is given by the Supreme Court. Now, anybody who is aggrieved by that order cannot go to the Supreme Court. He will go in the form of either review or in the form of a curative petition. But that is no remedy. So, in other words, a set of people who has to claim that I do not have any personal interest, yet he will have to file a petition before the court. And the court will have to grant an order on the ground that the dereliction of duty by the state, and whatever the order it passes, it becomes a judicial side order. At best, if it is a dereliction of duty, that state should have acted. If the state would have acted whichever way, in the same fashion that the honorable judges are passing the order, then the other person who is aggrieved of can go to the 226 and 32. In other words, a set of petitions in the name of the PIL filed in the court is wiping out the Article 32, 226 and other remedial measures of other agreed parties, possible agreed parties. The innovation which started in 1984, the Honorable Justice Bhagwati, that time that order was passed not against the individuals, but today's jurisprudence as PILs, which we are now staring at, is impinging and knocking the door of individual parties. And that is a judicial order. And it has a connotation. For example, I'm telling you that because of the environmental law, you know that National Green Tribunal was enacted in 2010. Prior to that, it was the T.N. Godavaran and M.C. Mehta under Article 32. These petitions these are all continuing mandamus are being issued by the court. The M.C. Mehta petition under Article 32 is filed in 1985. It is still going on in the court. T.N. Godavaran, it was filed in 1995 before the Honorable Supreme Court. It is still going on. Now, the orders that has been passed in these two cases has become a jurisprudence by itself. But if you see these recent amendments to the statutes, which is rendered by the parliament in appreciation of the effects of ground reality, they rather negate the jurisprudence. So what I'm indicating to you, what the question you had, that what is the public interest PIL jurisprudence? PIL jurisprudence is basically, I would say, that a public grievance remedy, which is the remit of the political institutions, is not the remit of the courts. And it is creating some kind of imbalances. And it is also creating some jurisprudential imbalances. How do you reconcile a judicial order in a PIL visiting private interests and private rights? What is his remedy? And if tomorrow the government wants to change it, the government may change it, because the government cannot change it. It is only the parliament will change it through a legislation. But today, on the anvil of the Article 21, on the anvil of your directive principle of state policy, the courts are stretching this jurisprudence, right to life, right to personal liberty, freedom of speech, etc., fundamental rights, and then your directive principle of state policy, even if it is not enforceable in the court. But these are the principles where the courts is borrowing it and and giving it in the form of their judgment. And there is a lack of reconciliation happening. And that is why we are having a lot of imbalances in the jurisprudential applications now. And how? The question is how? By making this statement, I don't think it will be beneficial to anybody. There has to be a demonstrable content for people to realize the benefit and the cost attached to any of our adventure and misadventure.
Quite right, sir. Thank you very much for that response. So the New Law College, Pune, boasts of being the first preference amongst the engineers in Maharashtra and in the country as well. So they have posed this question, like it goes like this: jurisprudential. I mean, as to what is the jurisprudential development in the backdrop of emerging new age technologies like Internet of Things, artificial intelligence, and machine learning?
Well, yes. Currently, whether it is AI, whether it is blockchain, whether it is other technological innovations, I'm telling you, they are not at all applied even in the implementation stage. We have not entered into the first stage as far as thinking of artificial intelligence level in judicial governance. It will take some time. Let me tell you, there are two things where artificial intelligence can be applied. As far as the question's answer is concerned, there is no judicial development of jurisprudence has been attained as yet, because of the lack of infrastructure, because of the lack of intellectual application also. Because none of the college in India today, education, legal education, has factored any of this technology in true sense. Number one. Number two, even in the process, implementation process, whether it is judicial governance, we have not gone to that stage. But tell you those engineers, I tell you there is a huge advantage. Let them do one analysis that Chinese have developed an artificial intelligence based model in file management system. and file implementation system at a very nascent and threshold stage. When we talk about the jurisprudence, this is actually the end stage. Jurisprudence means what? Now, principles will be developed by the court through interpretation, through application of law. When the judicial governance, that is the system of administration of justice, is not implemented, has not implemented any artificial intelligence tools, expecting a judicial jurisprudence, a principle, to come up early is not something we should dream of right now, right away. But yes, we must put it in our scheme of things. And to begin with, try to analyze different different countries' development of law. Many people are now started using it like this. As I told you about in the drug and cosmetic law, new law, I have designed a mathematical model where I have stated that I have also put in some experts into it. And it's like in cricket, I think most of you know about the cricket. In cricket, one of the model they use is called the Duckworth-Lewis model. Similarly, this is a tool which is developed by us, which makes the judicial governance and administration much, much easier. Almost 90% of the cases will go on day one. Imagine the amount of the infrastructure that you will save. Number one. Number two, this is very nascent stage of application, but we are also developing the artificial intelligence level of jurisprudential application. But that is something immediately no one should try. Why? Because the jurisprudence that is staring us, they are not scientifically compatible. A particular provision of law or a particular principle have a possibility to give you more than two outcomes. Now, if you bring this kind of jurisprudence, because what is input will be the output. If the input is erroneous, output will be erroneous. If the as I told you, that jurisprudence that we are always reading these days are actually not in ideal sense correct jurisprudence. First of all, we have to develop the jurisprudence which is based on logic. If we will be able to secure them slowly but steadily, but it will take some time. Through the we will argue before the court. We will get it a certification from the Honorable Supreme Court. Finally, then that becomes the law of the land. Then you start applying that particular jurisprudence everywhere. That as I was telling you, that I have developed a logical table to demonstrate Section 24 of the Land Acquisition Act, that Fair Compensation Act of 2013. That was also used. That can also be used in the rape law. That marital rape section 375. I'm sure this will be in full glare in the Honorable Supreme Court when it goes to the Supreme Court or the third judge before the Delhi High Court. So, use of technology at a nascent stage, at the entry level is okay. But using it at a higher level, like a jurisprudential principle level, it will be fraught with a danger unless and until the input materials are corrected. Unfortunately, they are not very robust. That is why a particular provision interpreted by one court as A and the another court is a B. So where is that tranquility? Where is that uniformity? So that means there is an element of ambiguity left. And if it is left, the machine will always give you an erroneous outcome.
Quite right, sir. Quite right. Sir, I'm also happy to inform you that the New Law College of the Bharati Vidyapeeth, Pune has taken a lead role in establishing the Center for Artificial Intelligence and Law, CALE, teaching our students the symbiotic association which we can have between artificial intelligence on the one hand and law on the other. Sir, let me equally confess that we are flooded on WhatsApp with questions and special appreciation for your good selves on your, especially for your oratory skills. We have many questions, but we have space for just one more question, and I'll just put it across. The question being that a great deal of law students in our college aspire for joining the bench in the initial stages or after their practice. So what suggestions do you have for such students?
That's a very, very welcome idea that people going to the bench, we actually are looking for better brain in the bench side. And the new generation of lawyers going from the lower judiciary level, and hopefully with the generation growing with its gestation, will be able to reach to the top also. The same generation will reach to the top with the experience and exposure. But I have a piece of advice that while at every stages in the judicial governance, good analytical mind is required. That is at the practice level, that is as a lawyer, you need a lot of good analytical skill to be able to handle the cases with the least minimum time, flawless presentation. Gone are those days where the lawyers used to argue for days together. Today, you have to read the entire 1,000-page petition within 10 minutes. Same way, we also look for good judges on the bench who will have a better grasping ability. Because there is a huge clamor for better judges. With the infrastructure crumbling now, as you know, India is a growing economy. With the growth of economy, people becoming more empowered, will assert for their right, and therefore they will avail the court services. When a poor man doesn't know about his right, what he will assert for? If he will not be able to assert for what is for him, it is what is the requirement of the court. Second, there are people who are poor, they can't even afford it. So therefore, the great deal of students looking to go to the benches is a good idea. But I always will tell you that the system has a lot of limitations. And the system of our lawyers, even though I say that I am also a part of a system, but I have a lot of freedom as compared to a judge. And with that freedom, I see I am more empowered than a judge. But yes, these new breed of lawyers trying to take up the judiciary services as a career is a good sign. But with one piece of advice, do not treat it as a job. You don't know if you really do your job properly, the quantum of imagine a judgment of the Supreme Court. It has an impact for the entire economy. It may change the economy status. And similarly, a judge, whether it is a lower court judge or a high court judge, if they can come up with a better ideas of governance of justice, which is public centric, for that, again, element of innovation helps you a lot. Do not be, stereotyped. Do not be the same old methodology that, going with that inertia. Let you be little innovative. Always question yourself 1,000 times. Why this? Why not this? Why this? Why not this? You will definitely get the result. And I have all my best wishes to all of your students who are aspiring to become a judge. I consciously avoided answering directly. I tried to give it little indirectly for a reason. Because I'm a biased person, I will always say that try to become a good lawyer than a good judge.
Thank you, sir. Thank you very much. And so let me tell you, this particular event of ours, this particular show of ours will go down in the history of the Student Progression Cell as one of the best because of the content which we got to listen from your good selves. So with this, we now come to the conclusion of this session. We shall now proceed to the vote of thanks. It is to my honors today that I have got the opportunity to propose the vote of thanks for today's event. At the outset, we would like to fondly remember our founder, Chancellor Dr. Patangrao Kadam sir, because of whose blessings this event has been a great success. We are grateful to our keynote speaker, Advocate Biswajit Das sir, who could take some time out of their busy schedule and grace this occasion. We express our sincere gratitude to Honorable Advocate Rajendra Umap sir, Vice Chairman of Bar Council of Maharashtra and Goa, for participating in this event. We are thankful to our Dean and In-Charge Principal, Dr. Ujjwala Bindale Madam, for conceptualizing the idea of a student progression cell, thereby enabling every student at the new law college to sharpen their legal skills. We most humbly take this opportunity to thank our coordinators, Dr. Jayashree Khandare Madam and Advocate Karishma Patil Madam, who have endeavored and worked so hard to make the student progression cell what it is today. We take this opportunity to thank all our volunteers, members of our IT team through whose efforts we could connect through the digital space. Lastly, we thank all of you for joining in and making this event a great success. In the end, we once again say thank you.
Thank you so much to all of you. Thanks. Thank you.
Thank you, sir. May I request everyone to switch on their cameras for a group photo, please? Thank you, sir.
Thank you, sir. Thank you so much.
Thanks.